Good evening and welcome once again to the Defense Chronicles. This is Leslie Bocobo. Tonight we have with us Atty. Tranquil Salvador III. Good evening, Atty. Salvador.
3, 2.
Good evening, Atty. Salvador. My first question to you tonight is, what is the effect of the articles of impeachment's lack of proper verification? Isn't it true that the law says that the articles of impeachment shall be treated as an unsigned pleading? What does this mean?
Okay, that goes to the essence of the impeachment complaint.
Yes.
The requirement of the Constitution and our rules of court is that every complaint should be verified, and when you say it should be verified, the complainant should be placed on oath.
Okay.
And what is their attestation when they assign their names or affix their signatures? Yes. Their commitment is that they have read the same and they understood it. And that is the reason why they are being sworn to them, and that's why they have signed the signatures.
Okay. Now, what is the effect of an unsigned pleading? Doesn't it further say that it produces no legal effect?
Yes. If it produces no legal effect, as if it was not filed.
Right.
Ergo, and therefore, there is no reason to even entertain the document.
Right. Ergo, isn't the Senate trying an impeachment complaint that, in law, has no effect? A pure abuse of constitutional clause.
No.
These are the questions now
Yes.
that are being thrown to us.
Well, you have to understand that this has been our basic defense at the outset.
Okay.
We have discussed this through the preliminary hearing of the affirmative defenses, although we were not allowed to present evidence. And at the outset, or at the start of our presentation of evidence on the part of the defense, we presented Congressman Tiangco on this particular point,
Yes.
touching on this, on whether or not there was a proper verification and whether or not the complaint can stand based on the Constitution.
Yes.
So that's how we see it. And it doesn't mean, though, that it has been initially denied our ability to be able to present our side. It doesn't mean, though, that we can no longer raise this as our defenses.
Yes.
We continue to raise this as our defenses. For what reason? Please bear in mind that the 3 articles are on board one impeachment complaint.
Mm-hmm.
It's just like you're on a boat or you're in a car. And
Yes.
if the car is defective or if the vessel is defective, the entire articles, all of the articles of impeachment would have to fall. That's how we see it.
Okay. I'd like to ask you further, why is it that the Senate jurisdiction over the Chief Justice's impeachment, to some professors of the law, they say it is legally impossible? Because, you know, the articles of impeachment, they say it's unconstitutional. Does it lack the proper verification required by the 1987 Constitution? Is the joint verification based on 1, personal knowledge, and 2, authentic records?
Yes. You will have to look at it on if you look at it on an academic standpoint,
Yes.
okay, for purely academic
Sure.
purposes, it wouldn't stand, based on our position,
Yes.
that it has not been properly verified, they have not read it,
Yes.
and it was not properly sworn to. There was nothing there's nothing to attest, because there's no complaint. Okay, follow. Now, of course, the side of the Senate President, at the same time the Senator judges, is that it's now in our court.
Yes.
It's now in the Senate,
Yes.
and for that reason, we have acquired jurisdiction. And our Senate President, with all due respect, has repeatedly stated that after the documents or the complaint has been forwarded to them, they are what? They will proceed henceforth. That is their explanation.
Very well said, Attorney. Let's move on to another part of what's happening right now in the impeachment court. Section 12 of RA 3012, or the Anti-Graft Law, says public officials who are under investigation or prosecution for graft and corruption shall not be allowed to resign and retire. Hence, isn't the current government violating the law when they allowed former Ombudsman Mercedes Gutierrez, who was then under impeachment for graft and corruption, to resign without being tried by the Senate? Instead of executing the law, they violated it. Consequently, they committed 1, culpable violation of their constitutional duty, and 2, betrayal of public trust, which are grounds for impeachment. Can you Educate us on
Okay.
this term.
Again, on an academic standpoint,
sure.
you would see that that is an express provision of the law.
Yes.
That being sued and being held accountable under the Anti-Graft Law, the public officer concerned cannot be severed or cannot end his employment or his relationship with the government.
Yes.
But I see it differently, Although on an academic standpoint, I completely agree, but this is a different picture to my mind. It's both not only legal, but it's both and likewise political. In what sense? That I think, of course, this is how I see it. The head of state feels that for him to proceed, this part or this agency of the government should be on his side.
Yes.
And I think there are some things that we might not be aware of.
Yes.
As you know, in the goings on, in the workings of the government, and there may be some discussions on this. I'm not privy to this, and all I could do is just to surmise or to speculate.
Okay.
Although if you purely follow the provision of the law, the person should not be allowed to resign or allowed to walk away until such time as the person is held accountable. That's very clear under the provisions of the law.
Okay.
But it has already happened. She has resigned, and she was not made accountable under
That's right. Now, let's go to the time of then Chief Justice Renato Puno. We know that the Supreme Court under him already and finally resolved in GR number 191002 entitled De Castro versus Judicial Bar Council that appointments of justices of the Supreme Court and Court of Appeals are not covered by midnight appointments. Prohibition under the Constitution. Can you tell me, attorney, now why the appointment of the Chief Justice right now by then President Gloria Macapagal Arroyo remains under fire by President Aquino?
Let me give you some history about that.
Yes.
In the past, there has been some cases wherein the Supreme Court for lower judges, meaning
Yes.
for inferior court judges,
Sure.
have made categorical statements or declarations in decisions of the court that they cannot be appointed within the prohibitory period as provided for in the Constitution. But that's for inferior court judges. Although some would defer to previous experiences with certain individuals who are to be appointed who actually declined from appointment because they feel that that is a what?
Yes.
That is a midnight appointment.
Yes.
Now, let us see now the present situation. The Supreme Court, when that was an issue, I know that there was a lot of legal discussion on this. There were legal groups that instituted an action before the Supreme Court, this time asking a categorical ruling
Yes.
whether or not the sitting president who is about to finish her term could appoint a Chief Justice without violating
Yes.
the prohibitory period under the Constitution on what they call, quote-unquote, midnight appointments. To my mind, that has already been laid to rest by the decision of the Supreme Court. So any person who may have a doubt will have to respect the decision of the Supreme Court because that is the agency of the government that was given the right to what? To interpret our laws.
Okay.
The legislative has been given the power to prepare, to draft the laws. The executive has been tasked to enforce the law. But if there are issues, legal issues, which remain unresolved, it is left to the Supreme Court. And there are times that we do not agree with the decisions of the Supreme Court, and maybe it's unpopular. As in the case of Stonehill versus Diok, it was unpopular. But decisions have to be made. And at this point in time, being a lawyer, I think we will have to respect it.
Yes.
And that is one of the reasons, one of the reasons why I am here.
Okay.
I believe in the rule of law. I believe in the three branches of government, that they would have to respect each other.
Now, today, the impeachment court was hearing arguments between the defense and the prosecution. These were pertaining to the properties again of the Chief Justice. The properties have been examined and are now being questioned in the case, and we can see that a lot belong to the wife of the
Yes,
Chief
that's
Justice.
right.
Some of them she even inherited from her parents. Why is it that the properties of the Chief Justice or the wife of the Chief Justice are raised against the Chief? He said he had nothing to do with it.
We're actually surprised, and you know, there is a what you call this, there are some ideas or thoughts. Okay, there are thoughts that considering that these are properties of the wife, it should have been declared in Sal N.
Yes.
But we have to be very careful about this, because the cash that we're even talking about,
Yes.
the 34 million that was obtained from expropriation, is not the personal cash of the wife.
It's not the personal
Yes,
cash.
yes.
Okay.
It's Basa Guidote.
Yes.
And I think that's not disputed because the check is in the name of Basa Guidote.
Yes.
The next question is, who is in control? Who is in control of Basa Guidote? And I think the people would know in due time
Yes.
that it would be the family of the wife of the Chief Justice.
Yes.
So
Yes.
there's a great difference between Mrs. Corona as an individual of being married to the Chief Justice,
Yes.
and there's a difference between a juridical entity where the wife is a part of.
Yes.
These are two different entities under the law. One is a juridical entity, which is Basa Guidote, and the other one, Mrs. Corona, is an individual. Mrs. Corona could be part of Basa Guidote, but she has to be governed by the juridical entity, which is Basa Guidote. And I think in due time, we will have to explain that in the course of the proceedings.